Hi, my name is Brad Micklin. I'm an attorney and managing member of the Micklin Law Group, which is a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. Domestic violence is a very complicated process inside of family and divorce law, and it's even more difficult for a lot of people to follow because there are two different processes. There's the temporary restraining order, and then there's the final restraining order. Both are granted in different ways, and they both have different consequences. Temporary restraining order is granted to anybody who claims they're a victim of an act of domestic violence, and it can be granted at any time, any day, all year long. The process is largely informal, it's one-sided, and the court or judge usually doesn't require any proof. It's intended to be very swift, very rigid, and very easy to obtain. The reason is the defendant, the person receiving the restraining order, is supposed to have a trial within 10 days and defend against the allegations then. The hearing that follows a temporary restraining order is going to be a full trial. And at that trial, the person who filed the restraining order has to prove that an act of domestic violence occurred, that they are a protected party, and that they need permanent protection. You will then have the first time to defend against the allegations, to offer your proof, and to explain the situation. The testimony at a final restraining order is not always it didn't happen. It may actually be that it didn't rise to the level of domestic violence, or there's no need for permanent protection order. This is the process of the final restraining order. If the person who filed the temporary restraining order is believable and meets the criteria, you'll receive a final restraining order. If it's not, the order will be dismissed. If you'd like more information on any of these topics, you can go to our website at micklinlawgroup.com.